want to welcome everyone here to the Citizens Law School, dealing with the topic today of Know Your Rights, Montana Constitution's Bill of Rights. I'm Joe Sullivan. I'm an attorney in Great Falls with the firm of Davis, Hatley, Halfman, and Ty. I'm the APAS president of the State Bar of Montana and a current member of the State Bar's Law-Related Education Committee. And that's the committee that's putting this together. In that role, as a member of the Law-Related Education Committee, I would like to go ahead and, on their behalf and on behalf of the State Bar, tell you that it's an honor and a privilege to introduce to you Judge Anthony Johnstone, currently a U.S. Ninth Circuit Court of Appeals judge. The Ninth Circuit, for those that may not be as familiar with it, are made up of the states, mostly the western states in the United States, including Montana. So federal cases that are tried here in Montana, if one of the parties disagrees with the decision on it, then appeals to the Ninth Circuit Court of Appeals. A decision from a Ninth Circuit Court of Appeals panel can then be appealed, and the next step up from that is the U.S. Supreme Court. Judge Johnstone has a rich and diverse legal background. He served as a law clerk for Judge Sidney Thomas, who was at that time a United States U.S. Appeals Court judge for the Ninth Circuit. He had experience in private practice in a firm in New York. He was Assistant Attorney General here in Montana for the Department of Justice. He was Solicitor General for the state of Montana. And then he was a professor at the Montana Law School, or is now referred to as the Alexander Blewett III School of Law. He's also acted as a sole practitioner in Missoula. Judge Johnstone is a scholar and an experienced attorney, but what impresses me the most is his quality as an educator. The Montana Supreme Court holds an oral argument once a year at the annual meeting of the State Bar. At one point, we did that in the meeting that was occurred at Big Sky. And then Professor Johnstone and some of his colleagues put together material for students at Bozeman High and Big Sky High. And those students attended that oral argument. And then following that argument, we met in a separate room and discussed what they had heard. And when the time was up for doing all that, the students didn't want to leave. They just kept asking him questions. And he stayed until basically their teachers were dragging them out of the room, saying, we got to get on the bus, we got to get back to school. And so it was just the way he encouraged and fed their thirst. To me, that was a sign of a true quality educator. And I hope you feel the same way in the presentation tonight. So I give you Judge Johnstone.
Well, thank you so much, Joe, and thanks. I look back fondly on those arguments, and one of the things about this job that I miss is working with more students than I used to. Thanks to the State Bar and its Law-Related Education Committee. Thanks to my great colleague, Anna Conley, who really led the charge to revive the Citizens Law School. I remember when I would do this in person and in a classroom in Missoula, and it's really nice with the help of Joe Menden and the great team at the State Bar to be able to reach across the state on this important issue, an important issue that is really an issue that is distinct to Montanans, our state constitution and our rights under it. I want to just mention that I have the Q&A open, so Joe and I can both monitor that and keep an eye on any questions that arise. I'm going to give a pretty quick tour through some highlights of our rights under the Montana Constitution and how that works and how it relates to the federal Constitution. But I'm happy to take questions as they occur, and hopefully I'll leave some time at the end for any additional discussion. So thanks to all of you for tuning in on this November 1st night. Let's see, let me get the one more time. Okay, everyone see that?
And I can see that, yes.
Is trying to keep it from turning off when I advance the slides. So I've got a lot more here than just this front slide. Let me try it over here.
And
that work?
That shows the second slide, yes.
Okay, good. All right. So I'm going to go through, set the stage for our constitutional right as Montanans by talking a little bit about the structure of government. I think one of the things I was just reminding my students this week is the reason we have government is to protect rights. And we often think about rights as protections against government, and those rights are that's the primary function. But our rights, our lives, our liberty, our property exists both before government, but we require government to protect it. That's the primary function of government, and that's one of the things that the Montana Constitution is explicit about saying. The Montana Constitution's Declaration of Rights in Article 2, right after Article 1, where we accept the terms of the deal that Congress provided us under the Enabling Act back in 1889, and accepted the federal constitution. The very next thing we do in Montana is, unlike the federal constitution where the Bill of Rights is tacked on towards the end, we put our rights up front in Article 2, and that reflects the idea that our form of government in Montana exists primarily to protect our rights as Montanans, the rights that we have defined as Montanans. So after a brief introduction of how this all fits in the federal picture, which you're probably maybe a little more familiar with, most people are, then we'll talk about the powers in government that exist and work to protect our rights, and then we'll talk about a sampling of a few rights and then leave some time for questions. So let's talk first about this idea of popular sovereignty. Popular sovereignty, which is expressed in the preamble, basically means that the Constitution belongs to us. It's the people's law. We, the people, are the ones who made this law, and it is our supreme law. And the preamble explains why we formed this Constitution. The Montana Constitution was formed by 100 ordinary elected citizens drawn from across the state in the winter and spring of 1972. And they spoke for other Montanans in terms of drafting the document. But what made the Montana Constitution our Constitution was after they brought it forth to the entire state, and then we, the people of Montana, through a statewide vote, voted for the Constitution. And this preamble expresses exactly why we have a Constitution. You can see there that it not just appreciates our lives and the place we get to live as Montanans, but also these ideas of improving the quality of life, the equality of opportunity, and secure the blessings of liberty. In other words, our rights as Montanans, our rights as people for this and future generations. So, of course, we have a federal constitution. The federal constitution chronologically comes before the Montana Constitution. But the first constitutions in the United States, and the first state constitutions were being drafted even before the Declaration of Independence. As states began to try to shape what their future form of government would be under popular sovereignty away from the king. Those state constitutions then inspired the federal constitution, drafted in 1787, ratified in 1788 and 1789, with the Bill of Rights added in 1791. Now, part of the terms of the deal of this federal constitution is that the federal constitution in gathering the states within the United States and the people in the United States together, the federal Constitution is the supreme law of the land, and it overrides anything in our state constitution. It's very express in saying so. At the same time, and so whatever the federal government can do under the Constitution, right? Only what the federal government does that's constitutional is the supreme law of the land. That overrides anything we might do, any of our powers or rights in the state of Montana, with the idea that we have delegated those federal powers to the federal government under the Constitution and under the terms of the Constitution. So there's a form of dual sovereignty. There are two we the people. We are we the people of Montana, and we are also we the people of the United States of America. In Montana, there are also in tribal nations, tribal constitutions. And so some Montanans are part of three we the people of Montana, we the people of their the tribe to which they belong as citizens, and we the people of the United States. That sets up various governments that work together with the federal government exercising supreme power under the Constitution. Then there are federal rights. And by and large, it was after the Civil War where our federal rights, through the 14th Amendment, the Reconstruction Amendments, began to be applied to protect us against our state government. First Amendment, Second Amendment, and so forth. Those are rights that we enjoy under the federal Constitution against the federal government. And after the Civil War, under the 14th Amendment, we enjoy almost all of those rights also against the state government. But in between that federal floor of rights and that ceiling of supreme powers is where state constitutionalism lives. And I think one way to understand that and the state constitution's relationship to the federal Constitution is the last two provisions of the Bill of Rights. The Bill of Rights, the 10th Amendment says that whatever powers are not delegated to the federal government in the federal Constitution are reserved to the states or to the people. What do we do with those reserved rights? Well, we give some of them right back to our state government to protect our rights at the state level. Some of those rights we don't give to the state government. Even in Montana, despite the fact that state law is most of the law, most of the law out there, 95% of the courts, cases, laws, all state and local laws, not federal laws. Even though most of the law is state law in Montana and across the country, still we reserve some of those powers even just to ourselves as the people. We deny even the state those powers. So the reserved state powers are where the state government powers tend to live under our Constitution. In addition to that, the federal Constitution, after listing several rights, most of which were inspired by state constitutional rights, retains rights for the people. And one of the ways I like to think about the Montana constitutional rights, the rights that we enjoy under our Montana Constitution as Montanans, is that that's a place where we have retained rights that aren't guaranteed by the federal Constitution, that there are additional rights out there. And some of those rights may be unenumerated and may not be expressed anywhere in any constitution, but some of those rights that aren't in the federal Bill of Rights, we express in our state Bill of Rights and throughout our state constitution. One study suggested there might be more than a dozen or more state constitutional rights that are not reflected in the federal Constitution. Yeah.
There's a question here. One of our guests is asking,
yes,
are we one of the only states that puts the Constitution back up for vote periodically?
Well, my friend John asks a great question. We are one that I don't know the precise answer to. So Montana is different than the federal government and the federal Constitution in that every 20 years, our Constitution requires we, the people of Montana, to re-up our commitment to the Constitution. And we've had 2 of those votes so far and passed by overwhelming majorities, actually much greater majorities than the original Constitution passed by in 1972. I think, I can't say that there aren't any other states that do it, but I think that it is uncommon for state constitutions to provide for that regular recommitment to our Constitution. So that's yet another way in which the Montana Constitution is special in that it provides for that vote, but it also ensures that we, the people of Montana, continue to support and sustain the Constitution, that we believe in it and the rights that it guarantees. So that's a great question. The next vote will be, I think we're about 10 years in to the next vote. So the next vote will be in the next decade or so. Great question. Yeah, and keep them coming. There's a really important thing to know that ties us to our state constitution regularly. So, state constitutional rights, where do they live? Well, they live in between the federal powers that the federal constitution provides and the federal rights. That's the baseline. Montana cannot violate your federal rights. They cannot violate your state constitutional rights either. The mechanism for this, by the way, is the oath that our officials take. The federal constitution requires federal officials to take a federal oath. The state constitution, the federal constitution also requires state officials to take a federal oath. The state constitution requires our state and local officials to take an oath to both the federal constitution and the state constitution, so that they are bound by oath to these guarantees in both the federal and state constitution. So they can't violate either of them. And in fact, judges, state judges in Montana enforce both the federal constitution requires them to do that, and the state constitution. Federal judges also can enforce the state constitution if it's raised, but they don't have a constitutional duty to do so. So that's how these powers arise and are enforced and how they relate to each other. Oftentimes you'll see people raising both federal and state constitutional rights, but today we'll focus on the special state constitutional rights that we enjoy. So first, as I'd said, the purpose of government is to protect our rights. And so it makes a little sense, I think, at the beginning to talk about the structure of Montana government, and in particular the way it's different from the account of the federal government that you may know. So first, we've got three branches. The branches are a little different than the federal government. So take the legislature. The legislature shares, unlike at the federal level, they share the legislative power with we the people. We the people can make laws directly through initiatives, and we can veto laws essentially through the form of referendum. That's not a power you have at the federal level. Now, this is a power, but you can see why people might think this is a particularly important kind of, almost kind of a right. You know, some people say we have the right as citizens to make law through the initiative process. We don't have to do it through the legislature. Whether you call it a right or a power, it's a very important difference between what we as Montanans enjoy under our state constitution and what we as Americans enjoy under our federal constitution. We can't pass laws by initiative. We've got to make law through Congress and only through Congress at the federal level, whereas we have this option of direct democracy at the state level. Another difference that we'll see is the state legislature has many more duties than the federal Congress has in the legislative branch. It has to balance a budget. It has to provide for education. It has to protect the environment under the Constitution. All of these duties are duties that we do not see at the federal level. Congress has very few duties at the federal level. The only real laws that it has to pass, if we want a standing army, we have to pass a Defense Appropriations Act every 2 years. Everything else is optional. There's not a list of what Congress has to do, unlike our list that what our Montana legislature has to do as a legislature. Okay. There are also limits on our Montana legislature. The Montana legislature, it's usually not bound by enumerated powers the way the federal government is. The federal government is a government of limited powers. The Montana legislature has general power, except in a few instances where it's limited. One example is the state legislature is unable to pass special or local legislation. They can't do their work only for just a few people or just a few towns or localities here and there. It's a tough rule to work out in practice, but it's an important one to make sure that our legislature works for all Montanans, not just for a few. And of course, even in the initiative power, we can't vote ourselves money. We can't, appropriations and local or special legislation are excluded from the initiative process. So we can't do quite as much as our state legislature can do under the initiative process. What about the executive branch? Well, separation of powers is not a term that appears anywhere in the federal Constitution. It's a principle that emerges from the text of the federal Constitution. But in Montana, separation of powers is explicit. No person from one branch can exercise the power of another branch. I think we're still working out over practice what that means between the different branches. And this is true at the federal level too. It's just the federal level, they've had more than a couple centuries to work that out. At the state level, we're still beginning to understand what are the checks and balances the legislature has over the court has over the legislature, the governor has over both. Another important difference is, and again, it's a power, but we can think of it as a right, is that we don't get, at the federal level, we get to choose through the Electoral College our president. We do not get to choose, right? Then the president chooses Secretary of State, the Attorney General, the Secretary of Education, and so forth. In Montana, as you know, as voters, we get to pick all of them ourselves. We get to elect our governor with the lieutenant governor. We get to elect our Secretary of State. We get to elect our Attorney General. And so, unlike at the federal level where the president may fire the Attorney General, the Attorney General is independent in Montana and shares that executive power. So just as we have a divided legislative branch where we, the people, share that power with the legislature, we have a divided executive branch where different executive officers share that power. And this doesn't even include things like the Board of Regents that controls higher education, the Board of Public Education, the State Land Board, which is put together of these statewide officers. We have a much more our executive branch is much more accountable in different elections to the people. And that makes an important difference about how they protect our rights. Finally, the judicial power. Another big difference is that we don't elect federal judges at all. Federal judges under Article 3 of the Constitution have always been, as Hamilton explains in Federalist 78, have always been appointed and confirmed by the Senate for tenure during good behavior. At the state level, Montana is like most states in that we elect our state judges. We elect our Supreme Court justices, we elect our district judges, we elect judges in courts of limited jurisdiction. And that's another way in which our Constitution and our government is more answerable to we the people in ensuring that they protect our rights. A big difference from the federal government. Okay. Any other questions about the powers before we go on the rights? We can always come up, if you come up with some, just let me know. I'm keeping an eye on it. Okay, let's talk about just a few rights. I'm going to mention 5, 6, depending on how you count. And that should give us plenty of material to discuss. So first, Montana has a couple of provisions in its state constitution that have deep, deep roots in American and English law. This first one is a really amazing provision that lots of other state constitutions have. Article 2, Section 3 talks about how all persons are born free and have certain inalienable rights. We might call them, in some traditions, natural rights. And then they have a list of these rights. And this is a list of rights that has been developed over time through the English Civil War and the work of political philosophers like John Locke, through to Thomas Jefferson and the Declaration of Independence. The Declaration of Independence does not set up a government, but we see some of those declaration style principles right here in our Constitution, and many states have these principles. It lists these natural rights that we have, not just as Montanans, but humans, right? It says all persons are born free and have certain inalienable rights, not rights that depend, not civil rights that depend on me being in a relationship to Montana as a citizen of Montana, but all persons have these rights. There's a list of them. It's worth noting that these rights are framed a little differently than the other rights we're going to talk about. Most of the rights are about pursuing things, pursuing happiness, in this case, enjoying and defending lives and liberty, seeking safety, health, and happiness, and then in all lawful ways. It's limited. And then Montanans tacked on to the end of it, noting that these rights also come with responsibilities. So what does that mean to have rights with responsibilities? Well, a couple of stories here. First, the origins of this provision of inalienable rights. As I said, this comes from a long tradition of American and English law and philosophy that says that we have these rights. And these rights are expressed not so much as limits on the government, but as duties of the government. These are really the rights. Remember how we started, that government exists to protect our rights? This is the clearest expression of what rights our government exists to protect. That's what it means. We're born and have certain inalienable rights. Of course, we have to, some of those rights, when we enter into government, we have to make some compromises. That's one of the puzzles of calling these inalienable rights. But when we enter government, the deal is we're entering government so that government will protect these rights for us, because these are rights that we had even before we entered government. That's why we set up government. So it's a very kind of nuanced, complicated way of viewing it. The way that it's treated in modern times is that the court reads this as a list of very important values we have as Montanans, very important rights we have as Montanans that require some special attention by the courts. So, for example, you may have heard about the right to a clean and healthful environment. The court has determined that that is actually, it's not just an aspiration, it is a substantive right. And it has taken actions to guarantee that, to hold the state to its duty to provide us a right of a clean and healthful environment. So it's not so much a limitation on government as it's an expectation of government that they maintain that right. There's language you might remember from a few slides back that there's also language that expresses a separate legislative duty to protect a clean and healthful environment. This kind of puts an exclamation point on that. Another thing that it notes, and I wouldn't be the first to point out the potential tension between these two things, is the rights of pursuing life's basic necessities. The court has also recognized that that includes substantive rights. For example, this is one I always enjoyed as a state employee. They recognized a right of state employees to moonlight in some circumstances. They recognized a general right to pursue employment to secure life's basic necessities. It's unclear what the exact scope of that right is, but again, our courts have looked at this provision, seen that this is an important set of inalienable rights that Montanans have, and in a series of cases, held the government to the terms of that deal. So those are inalienable rights. And then in some ways, this is the kind of the most exciting, innovative, and kind of one of the more potentially controversial. There's a lot of arguments over exactly what it means to put these inalienable rights into practice. But they're right there, and they're quite an inspiring set of rights that Montanans hold dear. Okay, let me look at our second set of rights. I'll move along here, and feel free, if questions have come up, you can put them in the Q&A forum. So Right after section 3 is section 4, which again begins with a sentence that sets forth a basic philosophical proposition. The dignity of the human being is inviolable. So again, note, these aren't just civil rights. These are human rights that everyone has, regardless of their relationship with a particular state or government. Then it goes on to add something that we didn't have in our 1889 state constitution, an equal protection clause. No person shall be denied the equal protection of the laws. That is one of the areas that was really innovated at the federal level. Our neighbor Wyoming has had a equality clause from the very beginning. One of their nicknames is the equality state. But in 1972 is the first time we, as Montanans, recognized a guarantee of equal protection of the laws. Basically, the government needs to treat people in equal situations equally. Then, in addition to that, there's a third sentence that goes beyond the Equal Protection Clause, which is a protection against law, government, and states a general anti-discrimination principle that echoes the big federal civil rights acts that apply not just to the state, but to any person, form, corporation, or institution. It bans discrimination against certain protected classes in civil or political rights. So here, think about employment, insurance, education, engagement with your government, a long list of your civil and political rights on several accounts: race, color, sex. Those should be familiar from the federal picture. Then a couple of interesting ones: culture, which the framers of the Constitution discussed in terms of culture that would include indigenous cultures, the cultures of our tribal nations in Montana, that this would require respect, both public and private respect, for those cultures. It's an echo of a provision in our education provisions that requires our education provisions to preserve the cultures of Native Americans in Montana. So culture is not something we have at the federal level, and it's something that 50 years on, we're still exploring and trying to sort out the meaning of. Same with social origin or condition. Social origin and condition, again, it was discussed back in 1972 as really referring to socioeconomic condition, class, some people would call it, that basically not just how you're born by race, color, sex, or which culture you're born into, but the social conditions that you may be born into, that you may have no responsibility for, that you shouldn't be discriminated on those grounds either. Again, that's the idea. It has not been well developed by lawyers in the courts yet, and so a lot of that work is still yet to do. And then, in addition, we have protections for freedom of speech. We have protections for free exercise of religion, but there's an additional protection, kind of a belt and suspenders approach, where they prohibit discrimination based on your political or religious ideas. And importantly, note that you're protected from discrimination on your politics or religious ideas against not just the state, as the free speech clause or the free exercise clause might protect you, but also any person, firm, corporation, or institution. I'll just end on this by saying that those last few phrases, culture, social origin and condition, political or religious ideas, those are really still in development in terms of how Montanans understand that and how our courts put that into practice in constitutional law. But they're very important. You see in the picture at the bottom, so the delegates all had homework. They all had a big stack. There's this amazing PBS documentary called For This and Future Generations, which you can watch for free. I urge you to watch it. It's about an hour long. Find it on the web, For This and Future Generations. And they have a picture of the delegates with this big stack of homework that the delegates had as they were writing this Constitution. And they got into really heavy political philosophy and Immanuel Kant and the difference between value and worth. This whole section, section 4, is the most cosmopolitan provision in our Constitution. It's the most It draws, as it should, because it's tapping into a tradition of human rights, not just civil rights, Montanans' rights, American rights, but human rights. It taps into a tradition that goes back to not just the Enlightenment, but the Renaissance and various religious thinkings on the dignity of persons and personhood, continued through the Universal Declaration of Human Rights, that was adopted after World War II, that spoke about dignity. The German Constitution, the post-war German Constitution, also guaranteed a right to dignity. And the immediate predecessor of this provision was actually the Constitution of Puerto Rico. Puerto Rico has the closest thing to this text in their own constitution. And our delegates imported it from there, this idea that we're still working out. So it's nice to acknowledge that Montanans are in conversation with history, with these big ideas, these big thinkers, and lots of other communities who have thought about rights in similar ways. Okay. Let's turn to probably another distinct right. Lots of Florida has the Sunshine Laws, the federal government has the Freedom of Information Act. Even the federal Constitution talks about, Congress keeping journals so people can know what's going on, the president having to give an address on the State of the Union. Those are pretty thin guarantees to Americans, constitutional guarantees for Americans who kind of want to know what their government is up to. In Montana, after decades and decades of citizens being in the dark about what their government was doing, where even some votes were hidden from people, the Montana Constitution added this right of participation, right to know. And this is even more than the right to dignity. This is quite an original idea, that the public has the right to expect governmental agencies to afford such reasonable opportunity for citizen participation in the operation of agencies prior to a final decision. So what does that mean? Well, it means, for many of you who may have gone to a city council meeting or gone to the legislature, it means that when they're meeting, they've got to provide notice of what they're going to do, what's on their agenda before they make a final decision. They have to tell you what decision they're thinking about, and they've got to give you an opportunity to participate. Oftentimes, it's just standing up and giving a minute or two of your thoughts on the decision, telling them whether you think it's a good or a bad idea, but that's required. And if they don't do it under laws that the legislature has passed, they have to take it back. They have to redo it. So this is a really important right to allow us to participate. One of the things that Montanans discovered early on, as they were developing the right to participate in our government, however, is that it doesn't do you much good to participate if you don't know what they're doing, right? So there's a case, for example, there's a case out of Billings, something I think a lot of us can think about as parents, where the school board was looking at closing some schools. And they'd had a group of people involved with the school board, some parents and school board trustees, have some meetings on the side to try to develop a spreadsheet and score which schools might stay open or stay closed. They did that work outside of the school board. School board met, they'd had this list, they talk about it, they discuss it, and they decide we're going to close these schools. Well, a parent came in and sued and said, wait a second, how can I have a right to participate in the decisions about which schools we're going to keep open and closed in our community if I don't know the reasons why you might open or close these schools? If I don't have that score sheet that you have, you've got information about these schools. You're relying on information about these schools that I don't have. And my right to participate isn't any good unless I also have a right to know. So our Montana Constitution provides also, right after the right to participate, a right to know. It says no person, not just any Montanan, but no person. So, right, a book author from Colorado, companies, all sorts of people can come and look to see what the Montana government is doing. What are the documents that they're relying on, that they're using, their official documents? What are the deliberations, right? They can tune in to that. How does that work? Again, oftentimes this might be virtual, but oftentimes you might just be right there in the room. Now, note this is different than the right to participate. The right to participate, you've got one shot, at least one shot before a final decision. But this right to know doesn't turn on the decision, it turns on the deliberations, the discussions that they have. There may not be a decision at a certain meeting, but you still have a right to understand what they're talking through and what issues might come up down the line. There's also a limit here. It's broader than the right of participation, but it's also limited in an important way. It's limited by our right of individual privacy. And so there are going to be times when government is dealing with our personal records, where we have an expectation of privacy, and the constitutional right to know does not extend to those records. Even the courts have found, even for public employees when they're on the job, there are some things dealing with disciplinary proceedings that for employees who are not in a position of public trust, that government can keep private to protect the privacy of Montanans, even when they're public employees. So that's the right of participation and the right to know. Okay, what is that right of privacy? Well, the right of privacy doesn't just exist within the right to know, it exists separately. And this is one of those rights where it's so important, they start with a reason for the right. The right of individual privacy is essential to the well-being of a free society. So that right's out there, it exists. We can't have a free society without privacy, and shall not be infringed without the showing of a compelling state interest. The courts have gone back and forth, but have settled on the idea that this is mainly a right of privacy against the government, against state government, and that it has two different components. One is a right of informational privacy, a right against government snooping and surveillance to try to get information about you. It's paired with our rights against unreasonable searches and seizures that come in Article 2, Section 11, a right that we Montanans just amended to include electronic records and devices. So it's viewed as a right against, we can't have a free society unless we have a right of privacy against government snooping, surveillance, getting our information, getting our private information and using it against us. That's one piece, informational privacy. Another piece is what the courts have called autonomy privacy, and they're really different points along the same spectrum. It said part of that idea of keeping government out of your private lives is not just kind of snooping, but also telling you what you can or can't do. And so that's where the courts developed a right of privacy that's involved certain medical decisions, certain forms of intimate relationships, and so on. Together, that forms our right of privacy as Montanans. You'll often hear a right of privacy spoken of at the federal level in certain cases, but the federal Constitution doesn't have an express right of privacy. It's implied by certain principles and traditions that we share as Americans. In Montana, it's right there, and the state can only infringe it by showing a compelling, meaning a really, really important state interest. I see that Jacob has a question. Hi, Jacob. It's good to see you on. So Jacob's question, you might see it in the chat. The state government sometimes charges citizens a fee. So this goes back to the right to know for requesting information under the right to know. It'll charge you to collect documents and to review them, in part to make sure that they're protecting people's privacy. What do you think about the tension between our right to know and the government's need to administer the right to know without the right being too burdensome on the government? Another great question. I guess the first thing I'd say, and it may be the last thing I'd say as I think about it, because I don't want to get too much into specifics. It's something, as Jacob knows, is often litigated. Is that the legislature, to its credit, has been a pretty strong ally of the right to know and right to participate. And so they've enacted a detailed set of laws that provide citizens a mechanism to vindicate their right to know and right to participate, especially their right to know. They've provided something that they don't provide for most other constitutional rights. They provide for attorney's fees if you go to court because the government isn't protecting your right to know and you win. Unlike a lot of these other rights, you can get attorney's fees. So it makes it much easier for the everyday person who may not be able to pay a lawyer to access that. So I think those are all generally good things and shows that the legislature on behalf of the government has been good. One of the reasons they do that, by the way, is because most of the right to know requests, the legislature usually does stuff out in the open. Most of it's public. There isn't a lot of privacy in the legislatures, but it's those of you who've spent any time there. But the right to know is a powerful tool for the legislature to use. Right? The legislators also have a right to know about the government. They want to know what the executive branch is doing. And so that's another reason I think they've written pretty strong laws to guarantee this right. In terms of the balancing, we are just, there's just the reality that some balancing has to be made. So a person can't go into, if a person goes into the governor's office and says, I want every email you've ever sent. That could take, because there's a right of privacy out there, that could take a long time and a lot of effort and really distract state employees from doing their job. And so there is a need for balancing. I can't comment on how well they've struck it, but it's something the courts are keeping an eye on. And it's something that Montana's constitutional lawyers are keeping an eye on and are working to protect. So it's a great question. And I think it's a reminder that with all of these rights, the courts are asked to answer some pretty tough questions, balancing the right to know and the right of privacy, figuring out how these rights can be made to work. The right of privacy, for example, what's a compelling state interest? When can government infringe your privacy? So hopefully that partially answered your question, Jacob. Thanks for it. Speaking of courts, I'm just going to talk about, we're in the last 10, 15 minutes here. I'm going to talk about one last interesting and old right that our Constitution reflects. And if we think about the idea that our Constitution exists to protect, or that our government and our Constitution provides a government that exists to protect our constitutional rights. Part of government protecting our constitutional rights is making sure that there is that government has mechanisms to keep an eye on itself, to keep an eye on, to allow people to vindicate and enforce these rights. And one important way to enforce it, I don't want to say it's the only way, even though our sponsors are the state bar and the incredible lawyers that Montanans have working for them across the state. You can vindicate your rights by going to the legislature and testifying and getting a law passed. You can vindicate your rights by going to the executive branch and working to ensure that they respect your rights in its activity. But the typical example of enforcing your rights is you can also go to the third branch of government, the courts, to get justice. Constitutional rights, but also the more general protections of life, liberty, and property that our laws provide. That's what this section, this last section we'll talk about is, section 16. Courts of justice shall be open to every person and speedy remedy afforded for every injury of person, property, or character. There's a little exception that was plugged in there for a workers' compensation issue. And it ends by saying right and justice shall be administered without sale, denial, or delay. This is an important piece that holds the courts and the laws that are administered in the courts to a high standard of doing justice. It is a very old concept. This idea that courts shall be open and that justice shall be administered without sale, denial, or delay goes all the way back to 1215 and Magna Carta and King John in England, and this developing set of rights that really, as Americans and as Montanans, we inherited this idea that that the rights we have as people includes some right to get justice if you're wronged. Not just constitutionally, but if you're in a traffic accident, someone breaks a contract, right? Someone defames you. All of those injuries, our courts must be open to redress. And so this is a very important cornerstone of all the constitutional rights we have. The system of courts and lawyers working to vindicate our constitutional rights every day, and also all of our other rights, and to protect our families, our homes, our livelihood, our persons, our property, our character. This is an area that has been, again, an area where the courts have been working to develop exactly what it means in particular cases. But I think it's a good right to end on as we thank the State Bar for sponsoring this series, and as I encourage you to attend the rest of the Citizen Law School sessions that we have. We have a little bit more time for questions, which I'm happy to take.
So, Judge, you mentioned in your presentation a section that had been amended. So at the state level, how do we change, add, or amend to anything that's in the state Bill of Rights compared to what they do on the federal level?
That's a great question, Joe. So in addition to, in talking to John's question about our ability to vote up or down the whole Constitution every 20 years, we can amend it, and we can amend it much more easily than we can amend the federal Constitution. So the federal Constitution, Article 5 of the federal Constitution, requires a super majority to pass out amendments, and you can't have an initiative. Congress has to do it. Congress passes out, proposes an amendment. States can convene to do that. States have tried in the past, but we still don't have any constitutional amendments that have been done that way. And then what it requires is a supermajority of the states through legislatures or conventions in the states to adopt that. You know, if you do the math, it's about right now it's 38 states. You can imagine one house of the 13th smallest state could block a federal amendment. So it's very hard to amend the federal Constitution. Our federal Constitution is one of the hardest to amend. The state Constitution is much easier to amend. They worried about it getting amended too much, but to our credit as Montanans, we haven't amended it that much. They actually worried that we'd look like California or Louisiana, where their constitutions are amended all the time and their government is kind of stuck because they have so many constitutional duties and rights to worry about. We've kept our Constitution simple and short, even though whenever we want, 2/3 of the legislature, so any 100 senators or representatives, it doesn't have to be 2/3 of each house, or 10% of Montana voters can sign a petition to propose an amendment. And then when it goes, if it gets on the ballot, all it takes is simple majority vote to pass. Most of the amendments, we've amended our Constitution a few dozen times since 1972. So much faster rate of amendment than at the federal level because it's easier, but still a much slower rate than most other states. When we amend it, you go by simple majority vote. Most of the amendments we've done have actually come from our legislature. There have been a few amendments that have come from the people directly as well, but most of them come from our legislature. So that's another special thing about our Montana Constitution, is it's not just some untouchable document out there. It's something that we Montanans shape every day through living our rights under it, through the 20-year ability to re-ratify it, and also through this ability not just to amend it, but also to talk about amending it, to discuss it in ways like this. This is one of the important ways beyond formal amendment that we're able to support and defend our Montana Constitution is to continue to discuss and debate it in the way that we have tonight. Any other questions?
So I did want to point out.
Oh, good. Yeah.
If anybody wants to dig into the topic further, there's a text out there, the Montana Constitution in the state constitutional tradition. The author happens to be the person on the screen right there. So, but there is a text out there if you want to dig into it farther and learn more about it. And it looks like maybe we have one last question there too.
Yeah, well, Jacob is way ahead of us. He asks what other resources. I have written a book on the Montana Constitution. It's mainly targeted towards law students, but it's written in a way that mainly highlights the way that courts and other government actors have practiced under the Montana Constitution. And that's the book that Joe just mentioned, the Montana Constitution and the State Constitutional Tradition, published last year. A couple of other very accessible resources that I'd want to highlight. One would be that PBS, Montana PBS produced series or documentary, a 1 hour show on For This and Future Generations is the name of it. A great way to spend an hour. It's, it's a little dated, but it is as close to the documentary on the 1972 Constitution. It is the definitive documentary on it. And, we don't have that for the 1787 Constitution. We didn't have TV cameras there. So it's pretty cool. One other recommendation I'd make is that our Mansfield Library and the law school here at the University of Montana have, we just put up last year, Rob Saldin, who's a political science professor there, and I put together a collection of the original documents of the Montana Constitution, all up there, public, easy to see, organized, and it's called the Montana Constitution Collection. Again, you'd want to search for it on the web. It's at the Mansfield Library. And if you go, you can get in there and watch and read not just the debates on the floor of the Constitutional Convention, but the debates around the floor, the debates of we the people who were bringing proposals, helping draft this thing, showing up to hearings, arguing after the convention, debating kind of the Montana's own Federalist Papers, debating back and forth about whether we should ratify it. All of those resources are available for free in electronic form at the Mansfield Library's Montana Constitution Collection. And I'd recommend that for anyone who wants to dig deep and see these sources in the original.
Well, Judge, I want to thank you for giving us your time and your great knowledge on this topic. We really appreciate you helping us by putting together this presentation.
Of course. Yeah, thank you so much. I wish everyone a good night, and thanks so much for tuning in. Keep supporting and defending your Montana Constitution by staying involved.
Good. I want to thank everybody else for attending. Just remember that this is one of 8 sessions. This is actually the 4th session held at 6:30 on the Wednesdays during the fall. The next one is coming up on Wednesday, the 8th, dealing with water, property, and public land. Hertha Lund out of the Bozeman area from Lund Law will be presenting that. So we encourage all of you to attend that, and then there'll be 3 additional sessions following that. So thank you all for attending. Really appreciate it.